Hello, my name is Senior Constable Alana Jamieson, and I'd like to thank you for inviting me to speak on behalf of the New South Wales Police Force today. Firstly, I'd like to acknowledge the traditional owners of the lands from which we're all coming from today. I'm personally speaking from Tharawal land. I'd like to pass my respects to elders past, present and emerging, and I want to extend that respect to all Aboriginal people who are watching this presentation today. So these are some of the topics that I'll be discussing today. And what I'd like to mention is that policing of domestic and family violence is a large part of the workload of a New South Wales police officer. So to give you a bit of context, New South Wales police on average attend over 140,000 domestic and family violent incidents per year. We are actually legislated to do certain things in accordance with the Crimes, Domestic and Personal Violence Act, 2007. The Premier's priority to reduce domestic and family violence reoffending by 25% by 2023 also drives a lot of the initiatives and work that we do to ensure our community is kept safe from this crime. And let's be honest, it is a crime, so let's make no mistake about that. So these are some of the statistics that I've been able to arrange from Boxer, which is all accessible to everyone watching today. So as you can see that the Mid-North Coast on average per 100,000 people has approximately 561.6 DV assaults during the time frame of July 2020 to June 2021. So that's actually slightly above the average of New South Wales. So there is more domestic and family violence assaults occurring in your area, which I have no doubt those watching today are aware of. As with those people breaching ADVOs in the same Mid-North Coast LGA, so that's LGA, not actually policing LGA, it's actually local government LGA, just to be clear. So the rate for breaching an ADVO is actually slightly higher than the New South Wales average as well. These are just some of the approach principles and updates that I wanted to bring to your attention today. So pro-investigation means that we investigate all matters of domestic and family violence. And we are pro-investigation. We have to investigate all matters and gather as much evidence as possible prior to looking at viewing or charging an offender. Pro-prosecutions means where there's sufficient evidence that exists, we will put that allegation before the court. In relation to victim support, we have DVOs, domestic violence officers, safer pathway referrals, which are automatic for any domestic and family violence incidents that is recorded to police. The New South Wales Police Force also has a responsibility to ensure that all victims of domestic family violence are provided support and assistance, and that's in accordance with the Charter of Victims' Rights. We also are in partnership with Women's Domestic Violence Court Advocacy Service, which assists all female victims through the court process. Now, in relation to targeting reoffenders, the New South Wales Police Force has a three-tiered approach to this. So we have the AVO compliance checks, which we conduct. We have DVSTMP, which is a suspect target management system where we target those DV offenders for the crime that they have committed against another person. And we also have our domestic violence high-risk offenders team. So we have 6 regions in New South Wales, and we currently have 7 of those teams. Some of the proactive strategies that we have to ensure that domestic and family violence is kept to a minimum as much as we possibly can. We have the men's telephone counselling referral service, which is offered to all male offenders. It's an automatic referral to them. And also that happens upon application of an ADVO or at the charge process. So in relation to integrated, coordinated and interagency responses, as I mentioned, we have the safer pathway referrals, which are completely automatic for every victim of domestic and family violence. We have youth action meetings, which is in relation to youth, safety action meetings, which is in relation to domestic and family violence. And we also are partnership with corrective services, community corrections, in relation to DV offenders that are released on parole from prison and are placed on the domestic violence electronic monitoring process, which is essentially an electronic tracker that they wear, an anklet, if you will. Now, community awareness, this focus is achieved through community service announcements. The recent release of the first in a series of podcasts has been released at the State Crime Command podcast. New South Wales Police Force also are in attendance with interagency committees. We facilitate school-based education programs such as Love Bites, And we also take part in community messaging and social media and any DV events that are occurring in the local communities. This is just a snapshot of some of the achievements that we've had to date in relation to domestic and family violence. So in 2020, we actually established a whole of government steering committee in response to COVID-19 and domestic violence. We had community service announcements released in partnership with Drinkwise, acknowledging that people in isolation were potentially engaging in more drinking of alcohol, which, as we know, can be a catalyst for some further violence, not just in a domestic and family violence context. We also introduced a QR code for quick links to New South Wales Police DV internet page. And we also had some changes in legislation in relation to the lengths of AVOs, urgent applications to vary AVOs, and most importantly, which is a really big win, is the ability for victims to give evidence via audio-visual link or have a screening in the courtroom when giving evidence, or a preferred seating arrangement. That's really important win for victims. So essentially not having to have them enter the courtroom at all. We also had some DV information sheets for victims and offenders put out, which can be located on our DV internet page. And as mentioned previously, this year we launched series 1 of a series of DV podcasts on the State Crime Command podcast app. And the focus is on domestic and family violence in the criminal justice system, and really hearing from those victims of domestic and family violence. It's a worldwide platform, so it's going to be really beneficial. So in relation to investigating domestic and family violence as a police officer, police must investigate all domestic and family violence incidences. We gather the evidence when we're there, parties are separated, and we examine the crime scene and take some statements. The victims are offered a written statement or a domestic violence evidence in chief statement, which is via a camera, or they can actually ask to be recorded audio only. We've also got our body-worn videos that we record evidence on, and that forms part of the brief of evidence. So police action. After investigating a DV incident, we will make a report back at the police station. The notifications are sent automatically to support agencies, and we'll assess whether we have enough grounds to apply for an ADVO for the protection of the victim and any children involved. We'll also look at interviewing the offender, and that may potentially mean that that offender is charged based on evidence. One of the most important things we do when we are attending a domestic violence incident is we inquire as to the presence of any firearms at the location or another location, and we look at seizing those if we have grounds to do so. What I want to be clear in today's speaking is, if police suspect that a domestic violence incident has taken place and we are going to take an AVO out for the protection of a victim or children, we don't actually have to have the victim's consent to do so. I'll just go back one. It's actually legislated that we must apply for an AVO if we suspect or believe a domestic violence offence has been committed. The law requires us to take action if we detect such. So I just want that to be really clear. So a lot of the times, if an AVO has been taken out for the protection of someone, that is completely out of the hands of the victim if we have located or understood there to be a domestic violence incident taking place. It's actually a police process. I just wanted to touch on some of the AVO conditions that are available on AVOs. This isn't a one-size-fits-all. There are different conditions that will be used for different scenarios and different levels of violence. And I guess the fears certainly come into it, also with children as well. The situation certainly leads to what orders we will place on AVO. So we will ask if there are children in relation to the relationship or if they reside in the home. And based on also 25 DV Stat questions, domestic violence safety assessment tool that we use, the victim will answer those questions, and that gives police a good understanding of the level of fear, violence, and other incidents taking place in that relationship. So the safety of the victim is paramount, and police may add as many conditions or as little conditions as they deem necessary at the time of reporting. The AVO will proceed to court in the following days, and those conditions can actually be amended at court. Those conditions will be amended with discussions with the police, the victim, and WDV CAS or another support service involved, especially if there's a male victim. It's important that at that time the victim expresses their fears to the support services or to WDV CAS or to the DVO or the police officer themselves. This enables police to make a really informed decision regarding the conditions being sought and whether they need to be strengthened or removed. So as you can see there, condition 1 is a mandatory condition that is on all AVOs. And essentially that condition is reminding people of some things they shouldn't be doing anyway. They cannot assault, threaten or stalk another person, certainly shouldn't be damaging property. In relation to orders 2 and 3 and 4 and 5, that relates to contact. So as you can see, there's quite strict conditions that can be imposed on a person. If we follow on to the next page, condition 6 relates to family law and parenting orders. And then 7, 8 and 9 refer to restricting a location that the defendant cannot go to. And then order 10 relates to weapons and prohibited items. AVOs are made for a minimum of 2 years, and they can actually extend for up to an indefinite amount of time frame. So as I mentioned a couple of slides back, there was legislative change in relation to that. So we now have the ability in the courtroom to ask the magistrate to consider extending the time frame of any AVO based on the seriousness of the offences, and that discretion is left with the magistrate. So breaching an AVO. Breaching an AVO is a punishable offence. It actually is a criminal offence that carries 2 years imprisonment as a maximum. So breaching the AVO in general carries 2 years, as well as any offence that's committed during that breach, whether it be an assault or an intimidation. That's an extra offence on top of breaching an AVO. So the AVO itself is a civil proceedings. It's a court order that the court has said to the defendant, you must not do each of the following. If that defendant makes a choice to breach that order, then there will be criminal charges laid. So AVO compliance checks. So in relation to AVO compliance checks, this is the doing of Commissioner Mick Fuller. He brought these AVO compliance checks into place in approximately 2017. So both parties are spoken to when a check is completed. So an AVO check would require the police to contact the victim and check on their welfare, see if there's any breaches or any other information they'd like to report to police. And then they're required to go and speak to the defendant in person and I guess remind them of their responsibility to comply with the court order. Now, to give you a bit of context, as you can see on the screen there, this year to date, so we're only just heading into November now, we've already completed over 80,000 AVO compliance checks across the entire state. So this is simply getting on the toes of those people who have an AVO against them as the defendant, and reminding them that, no, this is not just a piece of paper. We will be checking up on you, and we will make sure that you comply with this order and certainly keep the victim, the protected person, and the children safe. So in relation to AVOs and family and custody court arrangements, a family law court order can be actually suspended in a local court under Section 68R of the Family Law Act. Now, the obligations in relation to family law court orders do lie with the protected person, the defendant, to actually advise police in the court that there are orders in place. And certainly if the safety concerns are paramount in these matters, then the magistrate has the ability to actually suspend those family law court orders in a local court, especially if the arrangements are meant to continue. However, there's been an incident of violence or the like, and then the fears are too high, and the safety of the victim becomes paramount and that of the children. If the family law court orders certainly conflict with the AVO conditions that we've taken out, then the AVO will take precedence over the family law court orders. It's important that orders are raised in an appropriate part of the court early, so very early on in the proceedings, to give time for the magistrate to review the AVO and the family law court arrangements and decide the best course of action. So in relation to condition 6 on an AVO, this prohibits contact with the pin-up but in relation to custody arrangements. So there are parenting plans which are set out by the Family Law Court. Those are the ones that can be actually suspended in court. So that's a parenting plan is a Family Law Court order. But in Condition 6 of AVO, there is the ability to have an agreement in writing in relation to contact with the children. That is an option that is available that both parties must agree to. So young people in DV, so youth action meetings are taking place in the Mid-North Coast. They talk about the young person and look at strategies and the safety of that young person, basically in a roundtable format. And this again is something that's taking place in a lot of areas, not just up in the Mid-North Coast. The Rise Up strategy, again, was developed by our Commissioner, Mr. Michael Fuller, and it connects disengaged youth with the workplace opportunities. So Rise Up incorporates job-ready programs, mentoring and vocational training for at-risk youth to build their engagement with education, employment opportunities and the community. And then we come to Love Bites. So Love Bites is a respectful relationship program for young people aged between 15 and 17. And I guess this is an introduction to young people to let them understand that there are certain behaviours in young people's relationships that are taking place that may not necessarily be conducive to a healthy relationship. So it's about getting them involved in that program in a school context. So young people in domestic violence. So these listed offences are not eligible for a young person to receive a caution or conference under the Young Offenders Act. And I want to make it clear, family violence between young children and parents does occur, and it occurs on both ends of the spectrum, whether it be the child towards the parent or the parent towards the child. Either way, it's not accepted, it's not okay, and it is against the law. In relation to a young person, we can actually take AVOs out against the young person for the protection of a family member, and obviously vice versa as well. Those are all dealt within the children's court arena. And the investigation remains the same in relation to a domestic violence incident. We speak to all parties. When talking to the young person, we will need a support person with them when speaking to them. As mentioned on the screen, intimidation and breaching in AVO are not covered under the Young Offenders Act. If either of those are taken place by a young person towards another person in a domestic relationship, they will be charged for those matters, as with a sexual assault matter as well. So we'll go on to the next screen, which is technology-facilitated abuse. So an example or some examples of some technology-facilitated abuse are account exploitation, offenders making fake accounts on behalf of the victim, stalking them, having malware attached to their phone, location and device monitoring, revenge porn, which I've talked about on the next screen, you'll actually see. We've got public posting and defamation, banking exploitation, and high volume messaging and gatekeeping. So gatekeeping refers to, in the relationship, there may have been an awareness that both parties had passwords to enter certain apps or streaming services. And once the relationship has ended, those passwords are still accessible and they start to change those passwords. And that's a way of gatekeeping and stopping the victim from having access to certain apps. So my advice in that circumstance would be not to share passwords. And certainly if the relationship is looking at ending, look at changing those passwords as soon as possible. So that's called historical device permissions. Also cyber stalking or harassment. And that can even be done on programs such as Stan, Netflix, YouTube and Disney. So please keep that in mind. So as we've seen on the screen, we've actually seen an increase in technology facilitated abuse, a steady increase actually since 2016. So in relation to revenge porn or what's called image-based abuse, we've actually had some legislative change in relation to that enables us to actually target specific image-based abuse offences. So we have intimate images which are stored without consent, distribution of them, which is done intentionally, and then anyone who actually threatens to record or distribute an intimate image as well. There's actually particular sections in the Crimes Act that enable us to take action on those offences. So in relation to surveillance devices and stalking, surveillance devices, it means you're unlawfully installing something on someone's device and without their consent, of course, and tracking them. So that's actually an offence under the Surveillance Devices Act. And stalking as well. So we would normally think stalking is physically following someone, but if you're tracking someone electronically, that is another means of stalking someone, especially with the new smartphones that have the ability to have location services on them. It's essentially a GPS tracker. So that can actually be an offence as well under the Crimes, Domestic and Personal Violence Offences Act. So it's important to check your phones for all these sorts of things, and I'll give you a bit of information now. So initially, if we don't know about it, we don't know about it. So reporting to police is paramount. Documenting the information that you've come across on your phone or that things are piecing together. So the more pieces of the puzzle that you bring to police, the more we can fit them together and try and understand what's going on for you and help as best as we can. Disabling location devices is certainly important. There are checks that can be completed on your phone to ensure there's no viruses or malware. Improving digital literacy. Now that means essentially popping online, and I'll give you a few things in a moment to have a look at, and upskilling ourselves. The younger generation, Generation Z, are certainly on top of all the technology that's available at their fingertips. But my generation, and I'm sure some of the generation watching today, we're not quite there with it. So we need to improve our digital literacy and upskill ourselves and be ahead of the game. And also checking vehicles for any tracking devices. So when you report to police or when you're bringing a victim to police, there may be grounds for an AVO. The type of abuse may provide some insight into other behaviours as well. So if there's tracking devices on a phone, then police would start to think, well, what's happened in that relationship for that person to feel they've got to track this victim without their consent? What other things are going? So we may start to question the victim about other things that are happening in their world that they may not have pieced together initially. So we're trying to build a picture of why this might be happening. Learning about things online is certainly important. Police have the ability to gain information from social media accounts for investigations. I'd ask victims, and if you could talk to victims as well, to when they come to police to report, some of the things we would like to ask them is, what is their internet and phone provider and their account information? What devices do they have, such as phones, computers, tablets, and cameras? Do they have any drones, any external hard drives, USBs, any electronic children's devices, which unfortunately can be manipulated at times by an offender who's really hell-bent on trying to surveil a victim? What accounts or apps have they been using during the times of abuse, such as social media or banking apps? Their email addresses, their phone numbers, do they have any cloud storage accounts, usernames, avatars, pseudonyms, online identities of themselves and that of their offender? And any information that relates to technology, such as passwords, tracking devices, ISP addresses, identity theft. So these are just some of the questions that we might be asking, especially if we're dealing with technology-facilitated abuse. We'd ask them to disable their location services. Malware and virus checking. Now, as far as I'm aware, some phone shops and IT providers can actually conduct these checks for someone on their phone. They'll especially be looking for apps that are running in the background, or some apps can actually be hidden inside others. Improving the digital literacy, as I mentioned. So there's the e-Safety Commission online, which has some modules that can be completed. I've actually completed a couple myself. And the Women's Safety and Privacy Toolkit has some tech safety information that's available online as well. Now, in relation to vehicle checks, if a victim is concerned that they actually have a tracker attached to their vehicle, I'd ask them to attend an independent mechanic and have that mechanic check over the vehicle. If they do happen to find a device, I'd ask that that mechanic and certainly the victim not touch that device, ask them to use gloves, and then proceed to put it aside and actually have police look at that. That is a serious offence, and any fingerprints on that item might actually assist in navigating that investigation better. So during the COVID-19 pandemic, police continued to police as normal. The DFV assaults during that time did not increase during the lockdown period, but our AVO compliance checks did increase. These are Boxer stats. So these stats are available to everyone watching today. They're public statistics and they're specifically from police computer systems. There's no evidence that the assaults were increasing as a result of the isolation period. Now, these stats have taken between March 2020 and through to April, and then beyond through to December 2020, when restrictions started to ease. I just want it noted that I'm only referring to matters that were reported to police. I completely understand that yourselves in the DV sector services may very well have observed an increase in calls and requests for assistance. That assistance did not follow through to reports to police. As long as those people are safe, that's what we care about. This is the QR code that I'd mentioned earlier. Now, this QR code will take you direct to the police internet site, where there's extensive information on domestic and family violence, how we police domestic and family violence, what it is, and any other information that we have available for you. There's also a quick exit button on the police website as well. And that is all I have for you today. So I'd just like to say thank you on behalf of New South Wales Police Force for letting me present today. And I look forward to speaking with you or working with you all in the future.